should not leave your seat when your testimony is concluded being under the belief that the commissioners are suggesting that General Masemula has no case to answer insofar as the PFMA is concerned. We are not suggesting that at all. What we are focusing on is IDAC's mandate. IDAC, insofar as the PFMA is concerned, on our reading, IDAC's mandate is only if there are other charges and then the PFMA charges are additional to that. That's all that we are saying at this stage. It's about IDAC's mandate.
I hear
You see what I mean?
I understand.
So whether or not PMA offenses have in fact been committed is something else altogether, but it's not something that must be pursued by IDAC. That's all we are suggesting to you.
Thank you, Chair.
Thank you.
Yes, thank you, Chair. Good morning, Advocate Johnson.
Good morning, Commissioner.
I'm going to deal with process leading to the charges by IDAC. So the Section 27 affidavit or
Sorry,
additional...
Chair. I think sorry, Commissioner Kumalo. I don't know if the Chair found his file. It was about file 9. Sorry.
Yes, yesterday already I did. Thank you very much, Advocate Johnson.
In your response to Chair, you referred to General Matlow's affidavit. So if you look at General Matlow's affidavit starting on 3519, what she says in 3520 in relation to General Masemola is that, so first of all, she's the head of risk and integrity, so head of risk and compliance at SAPS. And she would have investigated these issues, as I'm sure her job description requires her to. And then she says in paragraph 8 on 3520, she then advised General Masemola to consider terminating the contract with Medicare to save SAPS from irreparable harm and to diminish the financial prejudice suffered by SAPS. Then she says General Masemola terminated. So General Masemola accepted the advice. Do you see that?
Yes.
Now, if you read Section 86 of PFMA with Section 38, what it requires is willful and grossly negligent conduct on the part of General Masemola. As I understand those two sections, they would kick in if, notwithstanding the advice by the head of risk and compliance, he does absolutely nothing. Because then that would be willful and grossly negligent. But if your head of risk says, I've investigated this, here is an audit report that shows that at the time when you did not know, some members of SAPS in supply chain were colluding with Mr. Matlala's company. And as a result, this contract was concluded. They were also colluding in relation to the issue of, I think it's in charge 3, of the orders, of the purchase orders, which is not something that as a commissioner you would generally know because it happens at supply chain level. If now head of risk investigates, gives you an audit report and says, the purchase order process and even the granting of the contract from the beginning were tainted by criminality. You as accounting officer, you come in at that level and you say, now that I have all this information, what do I do with it? And if upon receiving that advice, you terminate the contract, where is the willful, intentional conduct and the grossly negligent? Because the way these charges are formulated, IDAC is basically saying from the date the tender was awarded, because they say from May 2024 until May 2025. So they say from the date the tender was awarded, already there was willfulness and grossly negligent conduct on the part of General Masemola. But that cannot be if you look at the issue of the purchase orders, for example, in count 2. Those only started coming in after the tender was awarded. And payments only happened after services were rendered. So it cannot be that from the 8th of May already, because there was no tender on the 8th of May. The service provider was appointed in June, and after they were appointed, we've had evidence that there were then meetings about how the contract is going to be implemented. And the contract was then implemented much later from September onwards, if I remember Brigadier Macheng's evidence correctly. So it's not clear to me how in May, June, July, August, PFMA breaches could have occurred on the part of General Masemola. So do you see where I'm going? That you can only sustain the PFMA charges, the ones that are formulated at least. There may well be others that he's guilty of and we are not aware of. But the ones that you have in count 1 to count 4, you can only sustain them if, after he has received advice from the head of risk, he ignores that advice and allows SAPS to continue with this contract. I know I've said a lot, so maybe respond only to the last part. Assume that everything I said before the last part was just background.
So how I understand it is that from the time that he was informed by the risk officer,
Yes.
General Matlow, he took quite a bit of time before he acted on the information and the advice given. And it is precisely because he took a long time, it is in that period that monies became released. That is how I understand it.
Do you accept that, like any of us, when you get opinion, you first have to consider it, you first have to apply your mind to it before you act? Because if you act in haste, you could be sued for breach of contract, you could be sued for failure to apply your mind. I mean, some of the issues we've criticized you for was blindly accepting briefings without looking at underlying documents to satisfy yourself that, you know, the Section 27 read with the Section 28 applications are actually consistent and they are relevant to the complaint of Mr. Adams. So one does not, in the normal course, you get advice today, you act immediately. In the normal course, you would apply your mind to that advice and you would ask questions if there's a need to ask questions. Because I don't see anywhere in General Matlow's affidavit where she says it took the National Commissioner 6 months after he was given the advice to act on it. Because that paragraph 9 says, I gave the National Commissioner advice and then he terminated the contract. So there's no suggestion by, if General Matlow is the complainant, there's no suggestion by General Matlow that General Masemola did nothing with my advice or he took inordinately long before acting on that advice. And as a result of his failure to act on the advice, there was the loss. How I read this affidavit, it says the 50 million is what was paid throughout, not after the advice was given. But the charge sheet creates the impression that the loss happened after the advice was given.
If I could just indicate, Commissioner, that I asked if there was only the 27 at the time when they had this matter. I'm given to understand that General Matlow submitted a preliminary report together with the Section 27 affidavit. I'm not sure if it is before the Commission, but that must be something that that would then have to be asked, as it might just give a different context, but I'm not seeking to take the point further in terms of the conversation, Commissioner Khumalo, between you and I.
But looking at only paragraph 8, do you accept that the General says, I gave advice to the National Commissioner, the National Commissioner acted on the advice? The affidavit does not say the National Commissioner failed to act or did nothing with the advice given to him.
I understand that.
Yeah.
Still on this issue, my concern in the debate about whether or not this falls within the IDAC mandate is that on the charge sheet itself, there is no allegation of corruption. You don't make that allegation in the charge sheet. The charge sheet and the charges are purely statutory contravention, PFMA. And working off the charge sheet as it is now, the impression that it creates, or that in my mind has formulated, is that there was no good faith intention to prefer a charge because it is justified, it is supported by the facts. This was just a scheme to get him arrested or present to court, to have him appear in court, and the purpose is achieved just by that fact alone. So you don't even get to the validity of the charges. That's why we don't discuss with you whether there's merit in the charges themselves. That's for court to determine eventually if it does. But that which is obviously, at least in my view, which is obvious from the charge sheet and must have been obvious to the lawyers in your office and to the prosecutor who approves those charges, it must have been obvious just on the charges that we are not making an allegation of corruption against him. How do we justify him being here? That must have been obvious. And accepting, because it's difficult not to accept that it was that obvious to the lawyers who dealt with this. Accepting that it would have been obvious to them that this charge sheet is wholly inadequate for purposes of our mandate. There has to be another reason why. Anyway, you approved the charge. If you did do a prosecution memo, you were prepared to do the prosecution memo and say to the prosecutor, I think you said it's the DPP, and for the DPP to approve this charge as it stands without saying to you, hang on, go back, include corruption in there so that it falls within our mandate. To me, it gives the impression that the whole purpose of this charge sheet was to just have him appear in court. Just have him, let's create a paper that presents him to court and he becomes an accused with a consequence that we now publicly know happened, which is he was removed from his position, whether it's a leave or suspension, whatever, but he's not in office. And I say that, and forgive me if I'm repeating myself, I say that because it's inconceivable to me that a whole lot of lawyers who looked at this charge sheet, none of them said, hang on, we can't do this. This is not good enough for purposes of our mandate. If we want to charge him as involved in corruption, even your interpretation that you gave to the chair this morning, if that interpretation had been discussed, it would find reflection in the charge sheet. However inelegantly expressed, if the idea was that, well, you know, he's implicated in the corruption, even if it's just these sections, but that connection, it would have found expression here with a lawyer's eye. And that it doesn't find expression suggests to me is because you couldn't do it. None of you could get to the point where an allegation of corruption is made or him is being linked to the other accused conduct. And for that, you couldn't go that far. But it didn't matter because the real intention was never to get a successful prosecution of corruption or a successful prosecution that comes under predicate. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with the consequence that naturally will follow, which is the minister and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial, and that was its only purpose. That's what it looks like to me. You may comment if you want.
And I do understand your reasoning, Commissioner Baloy, but at no stage was there an intention to make a spectacle of anything. The prosecutors looked at the case in its totality, and as I explained this morning, it relates to. I accept, the only part that I do accept is they didn't draw the link between the two. That in itself does not make the conduct malicious, and there was no intent to put him on show. It was to charge him as they did. That link is not there. That cannot be taken away, but it should therefore not be seen as it was used as an instrument. They still firmly believe in those PFMA charges as they put them, and in my discussions yesterday, I did highlight that the Commission does find we have, where is the link between the two, hence my explanation this morning. I took your point, but I have to clarify, there was never an ill intent. It might have been clumsily put in the way it is.
Or incompetently
put, but that does not make for ill intent at all. Thank you, Commissioner.
Thank you.
Seeing that we are dealing with these PFMA charges, perhaps let me take you to a different but related issue. Ms. Silo, please.
Yes, Chair.
Let me do so, Advocate Johnson. I'm sure you know what sections 155 and 156 of the Criminal Procedure Act provide with regard to joining accused persons in the same set of criminal proceedings? Perhaps for the record and those viewing these, for their benefit, those viewing these proceedings, let me read both sections. 155.
Chair,
Yes.
apologies, we are trying to project, so perhaps when you read, it will be projected as well. Thank you.
All right. Section
157.
155 and 156.
155
And 156 of Criminal Procedure Act. Yeah.
Coming up, thank you.
155 is headed, persons implicated in same offense may be tried together. So I would say, please underline even that heading itself. Of course, our law and interpretation says a heading may be a guide, but is by no means determinative. But I will say, let's underline it. Then the subsection 1 reads, any number of participants, and I emphasize what follows, in the same offense, so you underline same offense, may be tried together, and any number of accessories after, again underline, the same fact may be tried together, or any number of participants, again underline, in the same offense, and any number of accessories after that fact may be tried together, and each such participant and each such accessory may be charged at such trial with the relevant substantive offense alleged against, I will say, them. Surely, in charging General Masemula together with people charged with fraud and corruption, you did not rely on Section 155, subsection 1. I must be correct in that view.
That must be correct.
That's correct. Okay, let's go to, I don't think subsection 2 is relevant, so let's skip to section 156, which is headed, persons committing separate offenses at same time and place may be tried together. That too is quite crucial because I'm interested in it. If we look at what Commissioner must make the point I made earlier that a heading is merely of assistance and not necessarily determinative of the interpretation to be given to a statutory provision. Okay, let's go to the provision itself. Any number of persons charged in respect of separate offenses committed at the same place and at the same time, underline that. Now it's in the substantive part of the provision, so no longer just the heading. And or at about the same time, so that too, at about the same time, may be charged and tried together in respect of such offenses. And then here's another crucial part. If the prosecutor informs the court that evidence admissible at the trial of one such person will, in his opinion, also be admissible as evidence at the trial of any other such person or such persons. Do you think this subsection applies? Or rather, this section, it has no subsection. Section 156, do you think it applies? In what way has General Masemola, based on the PFMA charges, committed those PFMA charges at the same place and at the same time as the commission of the fraud and corruption? Surely that cannot be suggested, I do not think. Same place, same time, about the same place, same time as the commission of the fraud and corruption? Not by any stretch of imagination, I do not think.
Correct, Chair.
So General Masemula was wrongly lumped with these other people. You must accept. You accept that?
I see that.
You certainly must. Now, even when you look at jurisprudential precedent, I will refer you to, I know you're a good prosecutor. I watched you arguing, which appeal was it? The Pistorius appeal. You are actually a good advocate, I think, on my assessment. I will refer you to jurisprudential precedent with regard to the court's exercise of discretion under section 1, under one of the sections I've just referred to. It should, I think, be relevant more to 156. Let me just see if the case was dealing with 156. Anyway, let me not waste time. Let me just read you what Trolip J.A. held. He says, in exercising its discretion, the trial court has to weigh up the likelihood of prejudice to the applicant accused. That is, the applicant accused would be the one saying, please, please, let my case be separated from the cases of these other accused. So the applicant accused, resulting from a joint trial against the likelihood of prejudice to the other accused or the state if their trials are separated, and decide whether or not, in the interest of justice, a separation of trials should be granted. Prejudice there means prejudice in the sense that no injustice should be caused to the party concerned, including the state. If we look at this, but what's crucial is that you've already accepted that in any event, General Masemula ought not to have been lumped together with these accused persons that are charged with fraud and corruption. Bear in mind that yesterday you accepted already that General Masemula is not complicit in fraud and corruption. Now you accepted now in my engagement with you now that he ought not to have been lumped together with these people. Now that he has been, surely, and based on this principle, you must also accept that he would suffer the sort of prejudice that Trolip J.A. says an accused person should not be subjected to. And I cannot see any countervailing arguments to the effect that the state will suffer any prejudice if he is not lumped with these other accused persons. Do you agree with me?
And if, I think when it was flighted, section 157.
Can you just respond to what I suggested to you now?
And I wanted to say that because of, if you read 157,
yes.
that becomes a bit more, is more appropriate than in the circumstances and given the jurisprudence.
Yes, yes. But you basically agree with me, you've already agreed that he ought not to have been lumped together. Then I'm making another point, although related, which is that he will definitely be prejudiced in a trial that lumps him together with these other accused who are charged with fraud and corruption, both of which he is not charged with. Do you accept that?
I accept that.
Now, a question that goes to what I've always emphasized, I think I did so even on the first day, which is that we are not trying to suggest that General Masemola has committed no offenses, no. But, and this is something that Commissioner Baloyi's question touched on, we want to know why this was done. Why was this done? You've agreed very easily, you know these principles, you apply these sections all the time. Why was this done? Why was Commissioner Masimula lumped with these people, charged with fraud and corruption when he is not? When he is charged with the statutory offenses provided for in the PFMA. Why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him, to taint him and to make the public or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there, people charged with corruption, fraud. He stands there with them. And most of the noise when the case is talked about, it is going to be about the fraud and corruption. People are not going to delineate and say, but not Masemula. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I understand. I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemola was there an intention that he be embarrassed.
Were you
Not at
involved
all.
with the decision to join him as a co-accused in this, with the other accused? Were you involved with that decision?
Yes, the prosecutors take the decision. When we were briefed, we agreed that he's charged only for the PFMA.
No, my question is, someone made the decision that he will be accused number, whatever number, on that gallery,
The
right?
prosecutors.
My question is, before that decision or when that decision was made, were you party to that decision when it was made?
That he would be added at the end.
That he's added as a co-accused with the other, however number, whatever number they are?
Based on the contentions that I've given, which was given at the time, yes, madam.
You see, what's problematic with this is the fact that you have already agreed that in terms of the sections, he ought not to have been joined at all. He ought not to have been. Now, what makes this situation worse is the fact that he is being joined down the line. Not that it would have been correct if he had been joined at the same time the charges were brought. No, that would still have been legally wrong in terms of 155 and 156, and you've agreed to that. Now, but what makes it worse here, he is joined down the line. Surely, your minds should have focused on, we already have charges against all of these people. We are charging them with fraud and corruption. Now we want to put in an additional person. Is it in accordance with the law to join him in terms of 155 and 156? Surely your mind should have been focused on that. It's not as if a mistake happened, we just lumped these people together instantaneously, it sort of just happened. But anyway, I say, things like this cannot just happen. So if it's wrong in law, it would have been wrong, even if it was lumped right at the beginning. But now, the point I'm making is, you lump those together, they are all charged with fraud and corruption. It makes sense to lump them together in terms of 155 and 156. Now with him down the line, how is it that your minds are not specifically or particularly focused on, but must we lump him together with them? Surely your minds should have been so focused. Otherwise, I do not understand why that was not the case.
I understand you, Chair.
Did you? I may be
I know-
repeating Commissioner Baloyi's question, but I will repeat it for emphasis. Did you focus your own mind on this issue at all?
Yes, there was a discussion on whether he was going to be charged separately or whether he was going to be joined. I give the argument and can take it no further than what was given.
After that discussion, or during that discussion, did you specifically focus on which basis under 155 or 156 we can join him? Did you focus your minds on that?
Not me specifically.
When you say there was a discussion, did that discussion not involve you?
The discussion involved with 157. Should he be charged separately or should he be charged jointly? The prosecution
You
team...
can't, sorry. You can't separate 157. It must relate to 155 and 156 as well. You cannot separate because you charge people in the same proceedings if they have committed the same offense.
That discussion happens and then we go to we then go to Commissioner Masemola
So you were part of that discussion, you say?
with the prosecutors. Yes, when they did the briefing.
Yes.
There was an engagement with the prosecutors.
Yes. And you concluded that there was a legal basis in terms of the Criminal Procedure Act to join him in these proceedings. And if you say so, and you must have reached that decision. So if you say you found a legal basis, what was that legal basis? And in terms of which section exactly?
So in terms of the legal basis that we found, Chair, it was the argument was used as the at the bottom of 156 of them being charged together because the evidence at the trial of the one would be used and may be admissible at the trial of the other person.
Is evidence about the commission of corruption, the commission of fraud admissible as against General Masemola? If so, for what purpose?
Not admissible against him, but to lead that evidence to
No,
then
Joy,
show it.
Continue. Please continue.
Okay. It was in having this one trial, you lead the evidence of the fraud, the corruption, all of those irregularities. And it's all the same evidence that will then talk to the PFMA evidence, because you would have to lead, if you take him and put him separately, you would still have to lead that same evidence to get to him, to show what was the irregularities and or the unlawfulness that was happening, who all was involved, and what were his duties. So instead of duplicating that evidence, they put them all in one matter. We would lead that evidence. It will then in turn show that serious complex corruption, etc., that happened, had it been stopped when it should have been stopped, would not have led to this. Not doing it together, Chair, as was argued, would mean we'd have to do two separate matters. That was the discussion at the time.
Was that correct, insofar as is concerned? Remember, you just said, in response to my last question, you just said, evidence of the commission of corruption and the commission of fraud is not admissible as against General Masemola. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining the accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masemola, you do not get off the starting blocks under 156. Do you agree?
I agree.
So
I was giving you the discussions that we had.
Which were wrong ultimately in terms of the decision that was reached. Do you accept?
I'll accept it.
Thank you.